So like we were discussing section 7, so I'm going to write down section 7 here. So section 7 simply indicates, subsection 1 indicates what is an arbitration agreement. What is an arbitration agreement? Now in this particular subsection, one point is very clear. The arbitration agreement is with respect to the issues between parties, right, which may arise or have arisen. These are the two issues, right? And arbitration agreement issues may arise between parties. These parties must be under a defined legal relationship, in a defined legal relationship. And issues, or you can say disputes. Disputes can be all disputes or can be certain specified disputes. Certain specified disputes, right? And must be defined relationship. This defined legal relationship can be contractual, or this defined legal relationship can be other agreement. Now the point is that section 7 subsection 2 indicates that the arbitration clause, or the reference to arbitration, this particular can be a particular clause in a contract, isn't it? This can be a clause in a contract, or this can be a separate agreement. But both of them must be part of the contract. And further you will find that section 7 subsection 3 indicates that such an agreement, that so and so agreement shall be in writing. Now section 7 subsection 4 has three components, that is A, B and C. In A, it simply tells you, it refers to the document, any document which is the part of the contract and referring to arbitration. This document must be signed by the parties. And B indicates that any exchange of letters, telex or mail, which can serve as the record of the agreement. Now record of the agreement means that simply that it must be admissible, right? It must be admissible by the court. Record of the agreement. And C indicates that where any such exchange or communication between the parties, is such that where one party has referred the matter for arbitration, right, or has referred it to some certain clause or a document which has the arbitration clause, and in that same communication other party has not denied specifically. Now this is the scope of section 7, right? And at last we have subsection 5. Section 7 subsection 5, which indicates that if there is a contract between the parties which they are referring to a document which has the arbitration agreement, the only catch is that first it must be in writing. What must be in writing? If so and so contract is in writing, right? And second, such that the arbitration clause can be considered as a part of the contract, right? So there can be a separate contract also which is referring the matter to a document which has the arbitration agreement, right? So now the word document comes into picture. So we need to understand section 7 like this. So this is a simple definition, and you can understand that where they can play with you, they can play with you with respect to the clause in a contract. The clause was not in a contract, and there was no other separate agreement with respect to arbitration. They are silently not telling you this, so you will understand that there is no prior agreement for arbitration. The other is it must be written. So you should remember that oral agreements for arbitration orally are not considered as arbitration agreement, right? And any other clause, both must be in writing, duly signed by the parties, or any such exchange or communication between the parties which can serve as a record of such uh, communication, and that communication you are referring the matter to arbitration. Along with that, where there is another sort of communication where one party is referring that there was prior arbitration agreement between them and the other party is not denying that, so that particular document will also be considered, that particular communication will also be considered to mean the written agreement referring to arbitration. That is the scope of section 7 subsection 4. So this was all about it in short. I hope it will help you in note making and quick revision. I'll see you guys in the next.